Hello everyone, welcome to International Commercial Arbitration class. Today, we're going to talk about how award is being given and how it is being enforced. We will cover the different types of arbitration award and also the different legal requirements and format of final awards in arbitration. At the end of our discussion, we are expected that the students is about to understand the concept and process of arbitration award, so as you will be familiarized with the different remedies being offered to damaged party. And also, let us familiarize with the method of enforcing an award. Remember, the goal of arbitration is for win-win situation. Win for the side of claimant and also at the same time win for the position of respondent. When we provide an award, it should be valid and enforceable. There is only one decision contained in a single award. However, many documents are included prior to final award, like the conducts of arbitration, orders, and minutes of the meetings, contract of sales, and as well as other evidences. So for the awarding, okay, of the final decision, the arbitrator is going to weigh, evaluate, and assess the evidences for both parties, for both claimant and respondents. Whatever the decision of the arbitrator must be honored by the claimant and the respondents. Of course, when we discussed the qualification of arbitrator, we mentioned before that the arbitrator's characteristics and attributes must pass to the higher level standards of the international commercial arbitration law. Why? Because in international commercial cases, we are not only dealing with a single digit of dollars. We are dealing with a million, thousand amount in dollars of the commercial transaction. That's why if there will be some dispute, the final award is very significant. It must undergo, okay, it must undergone a series of investigation, and the arbitrator's qualification must not be questionable, and everything that must be undertaken in the process of international commercial arbitration must be legal, authentic, and acceptable. Let us define awards in arbitration. So awards are those decisions that the tribunal which dispose of issues between the parties and which will be given recognition and effect by the courts after studying and evaluating the evidences, the situations, and the arguments presented by both parties. The arbitrator is now going to decide who whom the dispute, okay, will favor. Okay, is it on the side of the claimant or in the side of respondents? So this award is equivalent to a judgment in a court of law. Whether all of the claimant's claim fail or successful, okay, the arbitrator must provide a reasonable award, okay, because the award should be done, okay, should be given, okay, with due process, in due process. So whatever the final decisions of the arbitrator is, it must be honored, okay, or recognized by both parties. The final award indicates two different situations. First, it means that it marks the end of arbitral proceedings and settle all claims between parties. Secondly, the final award means re judicata effect, meaning you could not proceed on the relitigation. Okay, it means that it cannot be challenged or it cannot be enforced. When the word re judicata effect is being given, it is initially means the final decision had been made by the arbitration or the court. There are seven types of award. Number one is interim award. So when we say interim award, this is a temporary award while both parties are waiting for the final decision of the arbitrator. So it may includes provisional order for the payment of money or the disposition of property as between the parties, or an order to make an interim payment on account of the cost of the arbitration. For partial award, it means that some elements of the parties or the dispute claim have been determined. Okay, they already have an initial findings about the dispute, but the other issues remain unresolved and need a further studies and need a further investigation prior to the final award that had been is about to make. For the third award is the consent. So usually during the arbitral proceedings, when both party had agreed to settle the dispute in a very simple way, or the respondents, okay, already concede, mention that, okay, I'm going to pay whatever I need to pay. Okay, I'm just going to fulfill whatever the task is written in the contract, or I'm going to negotiate with the damage, and the claimant agreed to settle the dispute, and then the arbitration proceeding will be finished, and then there will be given a consent award because both party had agreed for a particular decisions to resolve the issue. Performance award, this is the most common to see awards made in monetary terms. However, a party can be ordered to perform specific works and hand over goods or rights. For example, a contractor may be required to carry out remedial works in a building or ensure work is finished to the quality required. The difficulty is that these types of award create grounds for further dispute. An arbitrator should award a monetary award where possible in this instance to avoid escalation of conflict. So this kind of award had been made according to the solution for the dispute. Okay, so the arbitrator may ask the respondent just to settle the amount that is being uh, required by the claimant. So you have to perform whatever the decision of the arbitrator. Draft award, this is not binding on the parties until it has been confirmed by the tribunal. So it is like a temporary decision but not for implementation. Okay, so it means that this is like a temporary solution to the dispute, or temporary findings to the dispute, but it is not yet final and it's not yet applicable, okay, for the implementation. The final award, so this should be usually be in writing and signed. This is the final decision in the merit of the evidences that had been presented by both parties. Okay? The final award must contain reasons and state where the arbitration took place. It must also be dated, okay, for calculation of interest if the award requires for the payment for the claimant. Once the final award is made, this ends the proceeding. Okay, the final solution, the final result of the arbitration. And the last type of award is the additional award. So if in case that the final award had been made and then some other issues, okay, had been also raised that is not been included in the proceedings, okay, but of course, with authority, okay, there will be some further or additional award to be given. So this additional award will only be honored or recognized if some certain issues related to the claims must needed to be awarded, or must not that must be needed to complement. Therein, you could have the additional award. we could expect that the final award is somehow be a burden either for the respondent if the claimant is successful with their claim, or it is a burden per claim if they fail to prove that their claim is correct. Okay, but remember that the arbitration tribunal's objective is to have a fair trial, and the resolution for the dispute is favorable for both party. That's why in the damages that have been created within the dispute, they are offering some remedies. So there are ranges of remedies that can be performed as a part of the award. Number one, the tribunal may order the payment of a sum of money. Okay, so that is for the conventional damage. Okay, so the arbitrator is going to require the respondent to pay, okay, a certain amount, okay, in regards with the damage that been created within the dispute. And the second one is the tribunal may make a declaration as to any matter to determine in the proceedings. Like, for example, um, the arbitrator may decide it is the responsibility of the arbitrator to do the delivery on time, or the declaration that the property belongs to party A or the property belongs to party B. Okay, so those are some of the declarations, okay, in the arbitration award. Another remedy is in most of the jurisdictions, the tribunal has the same power as the court to what? So to refrain from from doing something, and we call it injunctive relief. And second one is to order a specific performance, okay, replacement or payment, okay, or and then they are also sometimes being mandated to do some rectification or correction or setting aside or cancellation of a deed or other documents. If the damage really had been done, you have no choice but to pay the damage or the cost of the damage that had been created between the dispute. Okay, not just only in payment but also to correct the mistake that had been done. Okay, to perform a task that had not been performed or that had not been delivered. So those are some of the remedies that normally, okay, given as a final award by the arbitrator. Specifically, here are the list of remedies that may be found in international commercial arbitration. But in general, even in American Arbitration Association or in London International Commercial Arbitration, these are the common remedies that have been provided, okay, to settle a dispute. Number one is order for the payment of money, declaration, okay, let's say the property, which whom it is belong, a specific performance, injunctions like embargo, sanctions, countervailing, tariffs, okay, rectification like if there will be some method to adopt or some system to change, or a product or a building to renovate. Then another one is punitive damages. Okay, so if there will be some injury, damage, or loss for its party, so if it is criminal or some violation of human rights or a damage of the property, so there must be a punitive remedy for that. Another remedy is interest. Okay, some percentage that must be added to the total sum amount of the money that needed to be paid, and of course the cost of the damage that must be paid. Now let's talk about the legal requirements, okay, of the final award. The award must be in writing and completely signed by the arbitrators. If there are three arbitrators, there must be three signatures. If there is only one arbitrator, the arbitrator must clearly sign the final award. And also, in the final award, it is written the reason why the arbitrator had given that such kind of a resolution for the dispute. More so, the award must state the seat. When we say seat, that is the place where the arbitration took place. And lastly, the award must state the date upon which it is made. Why? Because normally this is for the purpose of the calculation of interest. Let us now proceed with a discussion of the enforcement of arbitration award. When we say enforcement, it means that the act of observance or compliance with the rule. Even though that every institutional arbitration center is using their separate rules and regulations, okay, they have to comply with the state arbitration or the state applicable rules and regulation. Okay, under the New York Convention 1958, the award issued in a contracting state can generally be freely enforced in any other contracting state, only subject to certain limited defenses. Okay, so they can implement the award, they can apply the award as long as it will not be contradicting with the national law or the governing law of the states. The documentary format of final award is varied, or they have different format according to the institutional arbitration center. But in general, the format of final award must be in writing. It must contain reasons for the decision. There must be a date, the place of arbitration, the sign, the signature of all arbitrators. And here are the specific elements of the final award. You could see that the final award contains the name and address of the arbitrators, the parties and their legal representatives, the term of the arbitration agreement between parties. It also includes the summary of the facts and procedure, including how the dispute arose, and also the summary of the issues and the respective positions of the parties, an analysis of the arbitrator's findings as to the facts, and application of the law to this fact. So if there's a complaint, and then there will be a corresponding regulation for that. Then the operative part of containing the decisions. This is the specific in detailed explanation why the decisions had been made and what makes the decision to be valid and enforceable. When can we say that the award is valid, or when the award have a sound basis in logic or fact or in regards with the evidences? Number one, the award is valid when it is relevant to national law, applicable law, and governing law. It should complement the law of the state and the law that is applicable, and whatever is written in the contract. And it is valid when it is being done through writing, and there is a reason that there is a date of award, and again, it must be signed by both parties and arbitrator. Once the final award had been made, there are other requirements before it will be implemented. Number one, there must be an approval of what? If it is for ICC, AAA, and LCIA, it will be reviewed, okay, for validity until such time that the award or the final decision is authentic, valid, and reasonable, and then could be the time that it will be implemented and presented to both parties. And secondly, it must be communicated. Okay, both party must be notified, and they are going to be informed about the final decision. And lastly, this final award should be registered or deposit, okay, to the International Commercial Arbitration Institution wherein the proceedings had been undertaken for safekeeping, for record keeping, and for future purposes. So what are the effect or consequences of invalid award? Number one, of course, the final award should not be recognized or it should not be enforced. Okay? No final award to be implemented. Secondly, if the final award is invalid, okay, it will deprive the jurisdiction, okay, in the dispute. It means that it will question the functions of the arbitration. The credibility of the arbitrator and the institution will be in dispute or will be at stake, or their credibility will become questionable. More so, this invalidity of final award is a manifestation that the proceedings or the institution itself, okay, could not provide effective and efficient proceedings of commercial arbitration. That's why it is very important to become cautious, okay, of every decisions and every system of the proceedings to be undertaken. Okay, because if the claimant or the respondent finds some loophole or some mistake with the proceedings, every throughout the proceedings, okay, the step-by-step system will become questionable until the final award will be given. Okay, it might be experience some protest, okay, or it might not be recognizable by both parties. Now, Professor, can arbitration award be challenged? Okay? An award can be challenged if the parties of the agreement has no capacity, or let's say they have physical or mental inability to decide among themselves. Okay? Secondly, the award may be challenged if the agreement is not legal. Okay, it's not when the party is not legally binded. And the third reason that may make the arbitration award be challenged, can be challenged, is that when the decisions of the arbitrator goes beyond with the matter or the scope of the arbitration agreement. It meaning that the arbitrator made a decision that is not appropriate with the dispute. And the other one is the composition of the arbitral authority, or the arbitral procedure was not in accordance with the arbitration agreement. This is what I'm telling you a while ago, that every steps of the arbitration must be undertaken properly and in accordance with the arbitration agreement. Okay. The arbitration award can be challenged also when an authority, okay, or state law, okay, ask them to suspend the proceedings, or to hold on, or to stop the implementation of the arbitration award. And it can be challenged if the decision or the matter of dispute cannot be settled, okay, by arbitrations, or it means that arbitration should not do the proceedings of the resolution of dispute because it is relevant with the state law, or it violates criminal law or state law of the country. So therefore, the award is not acceptable. And lastly, the enforcement of the award would be contrary to country public policy. That is has a relevance with the previous reason, meaning it contradicts with the state law, or it contradicts or it violates the rules and regulations of the country. The final award is the key to end the dispute between both parties. So whatever the decision of the arbitrator will give a solution to the controversy that had been arise, okay, within commercial transaction. That is why it is very important for the institutional arbitration to take careful, systematic proceedings in dealing with the dispute of both parties. They need to analyze the evidences, study the situations, and um, they need to follow a specific rules and regulations that is not contradicting with the public policy to make the final award acceptable and recognizable. So I hope that you learned a lot from the different types of award. And if you have any further question, just send me a message and I will be much willing to answer all of your queries. This is your professor, Dr. Christine Joyce Himpao. Thank you and have a nice day, everyone.